I spent the morning with my Savior, which brought me through my afternoon. And by the time I reached the evening, my soul was singing hallelujah. Like a ship tossed and driven, I've been up and down. Like a prisoner in prison, yes, the devil had me bound. But I know my future's brighter than the past I left behind. Had a little talk with Jesus, and the victory is mine. I spent the morning with my Savior, which brought me through my afternoon. And by the time I reached the evening, my soul was singing hallelujah.
Good morning, and good morning to you all. Welcome to Good Morning with Caffie. I'm your host, and today I have a special guest. Her name is Miss Karen Brown, Esquire. Karen is my attorney, and I wanted her to come on today to talk about setting your house in order. First, I would like to read her bio, and then we're going to jump right into the show. Attorney Karen Brown is an outstanding example of what one can achieve in life through hard work and self-discipline. She was born and raised in the city of Paterson, New Jersey, where she attended the Rosa Parks School of Fine and Performing Arts and majored in theater arts. Miss Brown went on to attend Seton Hall University. So did I, Karen. So did I. Where she graduated magna cum laude with a Bachelor of Arts degree in criminal justice. Upon graduation from college, Miss Brown attended Rutgers Law School, Newark, where she made history as the school's first ever graduate to receive a prestigious public interest fellowship. She carried out her fellowship at the former Passaic County Legal Aid Society, where she represented public housing tenants and community organizations. At that time, Ms. Brown was honored by the President and First Lady of the U.S. for her dedication and commitment to the Paterson community. Ms. Brown also served Passaic County as an assistant county counsel and county adjuster, where she made history as the first African American to serve in these positions. Ms. Brown once again made history when she became the first African American in the state of New Jersey to be elected to the position of county clerk at the tender age of 30. She was also the first African American to be elected to any constitutional office in the history of Passaic County. She's a history maker, you guys. She is a trailblazer. Ms. Brown also served Passaic County in various other capacities. She was the Director of Economic Development for the New Jersey Community Development Corporation, President of the Camp Hope Commission, President of the Paterson's Education Fund, a Commissioner of Passaic County Board of Social Services, and a member of Congressional Redistricting Commission. She also served as a trustee of the Passaic County Bar Association. Ms. Brown served as the chief presiding judge for the Passaic Municipal Court, where she again made history as the first African American to be appointed to that position. She was also a judge of the Paterson Municipal Court. In addition, Ms. Brown has served as corporation counsel and head of the law department for the city of Newark, the largest city in the state of New Jersey. She also served as of counsel to several law firms in New Jersey and as the borough attorney for the borough of Roselle. Ms. Brown is the recipient of numerous awards and citations from various elected officials, bar associations, and community organizations, and has been recognized as a political trailblazer. She is currently the managing attorney for the law offices of Karen Brown and a contract manager for the Medical Center IT department for NYU Langorn Health. She is licensed to practice law in the state of New Jersey, the state of New York, and before the United States District Court for the District of New Jersey. She is also a member of the Supreme Court of New Jersey, District 11 Attorney Ethics Committee. Karen, this is a mouthful. Girl, I didn't know half of this stuff. You somebody.
Oh.
You are somebody. I am so proud that you are my attorney, and your resume, your everything is so freaking impressive. Yep, I said it. Freaking impressive, because it is. And you're just such a sweetheart, gorgeous, smart. I always say with my students, you're not my student, but I always say sometimes I look at my students and I'm like, wow, you are beauty and brains. And that's what you are. You are both beautiful and brainy with all of the accomplishments. Thank you for joining us today. Thank you.
Thank you, Reverend Risher, and thank you for your compliments. And thank you for having me serve as your attorney.
You are my attorney, and I wanted people to know that. And I have to say, it was a few years ago. I just needed to do my living will, my power of attorney. I just needed to put my own house in order. And when I decided to do that, and it wasn't an easy feat, because it brings on a level of depression, right? And when I started telling people I was doing this, they were like thinking, oh my God, is she dying that she wants to put stuff in order? And no, I wanted to live. I wanted to put this in order, have everything in place, even to the point of having my obituary done by Barbara Simmons. She came and she did that for me, pictures, everything. And then when it was time to sign and to get my witnesses, we made a little celebration, if you will. My pastor said that it was okay, our pastor, if you will, because we're members of the same church. He said, yes, come to my office and we will do the signing there. And I told him, I said, Pastor Tell, I need you to do this. And he kind of looked at me strange too in the beginning. My witnesses looked at me strange because they were like, is she dying? But truth be told, we are all dying. We just don't have a date of death, but we're all headed, in that direction. But again, I wanted to have everything in order. You helped, not you helped, you did. You set my house in order based upon what I wanted. And then we went to Pastor Teller's office at the Community Baptist Church in Inglewood, where my two witnesses were, a video person, a picture person, and we took pictures of the ceremony. And I called it a ceremony because I had Pastor Teller pray long life over me, because I believe, with long life, God will satisfy us, show us his salvation, etc. But we need to set our houses in order. Before you start to talk, I just want to say, I was watching DMX's memorial service, and Swiss Beats got up to talk, and he said, everybody in this room and watching me need to put their house in order. And I'm like, Swiss, you ain't never lied, because you're going to tell us about the importance of setting your house in order, what that looks like, what it looks like if you don't have it in order. And I'm just going to get out of the frame so you can just go on and tell us what we need to do. Go for it, Karen.
Well, you mentioned a very important point, thinking about it, and it made you a little bit depressed. And I think that is the part that is the most difficult part of the whole process, because the process is relatively painless. It's getting people to start thinking about it. And a lot of us don't want to think about our immortality, and they don't want to think about when we aren't, able to make decisions for our own on our own. It could be very depressing, but it's something that's inevitable. And the best time to talk about it and to prepare is when you are in your right mind and there aren't any emergencies, and you can really sit and think about what you want to see happen, how you want to take care of your loved ones, and not only taking care of your loved ones, but how you want yourself to be taken care of in the event that you're not able to make certain decisions for yourself. So it's a relatively painful process if you can get over the fact that, you are going to die,
Right, right.
and with the feelings associated with that. But once you get over that, it's relatively painful. A lot of people think that they don't need a will because, oh, I don't have anything, I'm not rich. But it's not just for rich people. If you have any kind of assets, if you own property, if you have personal possessions that you own, and if you have money in bank accounts, that anything in your name only, is something that you want to think about how you want that distributed. And the best way to do that is through a will. So those things are is very, very important, because I've seen a lot of families, um, you're already mourning a loss, but I see a lot of families in disarray. They get into fights about, property and things of that nature that are left over in the decedent's estate, and there's no plan for it.
Right.
So
And
it
who's
really
who
causes a lot of rift in families.
causes too much problems. And
Yes,
when you are mourning, you shouldn't have to be worried about who's going to get the shoes, who's going to get the house, the car,
exactly,
whatever monies that are in the account. You need to
exactly.
grieve and experience good mourning. That's what my
That,
ministry is all about. And that's why this conversation is so, so important. When you were advising me, and there were certain people that I needed to think about who would call the last shots for me.
right,
Girl, that brought me into tears, because it's like, who do I trust
right,
with the rest of my life, if you will, that will make sound decisions, that's not hating on me to get a piece of my pie, whatever I'm going to leave. So talk about the last will and testament, the power of attorney, the living will. Talk about these documents and what people should have.
your last will and testament basically sets out how you want your assets to be distributed. And an important part of that plan is, who do you want to be in charge of your estate? You talked about, when you thought about who you could trust and who would be responsible for carrying out your wishes. It's a very, very important role. So you need to name an executor who's going to carry out your wishes. And it really should be somebody that's responsible, somebody that you can trust, and somebody that you know is going to do and carry out exactly your wishes. So that's a very, very important piece of your will when you're determining who's going to get what, and then who's going to distribute it. And if you have minor children, you also want to think about who you want to be the guardian of those children as well. So those are some things to think about. And like I said, it's a relatively painless process. You think about how you want your assets distributed, and we write it out. We name the executor, and you need two witnesses over the age of 18 years of age. And they're not going to see what's in your will. They don't read your will. They're only attesting to the fact that you're over 18, you're of sound mind, and that you're executing the will voluntarily. And what in New Jersey, what we do is we do a self-proving affidavit, so that if anything were to happen, and when the time comes for your will to be probated, all you have to do, you have to wait the 10-day period. An original copy is brought to the surrogate's office, and you don't have to call in any witnesses. The surrogate's office can pretty much put your will through probate and issue the necessary certificates without having to have a witness come and testify. So that, again, like I said, it's a very, very simple process. But there are other documents that you should also put in place besides a will. One thing is, I always recommend a power of attorney. A power of attorney allows other individuals to act on your behalf in the event that you are unavailable. You could be out of state, or you could be incapacitated in the hospital, but you give that person the authority to basically manage your affairs during the process during the time period that you're unable to do so. So that could be doing banking transactions on your behalf, handling real estate, all kinds of decisions and things that you would actually be doing on your own had you had the ability to do so. And the power of attorney, again, is relatively simple. It doesn't even require a witness. It just requires you to designate who you would like to be your power of attorney. You sign and it's notarized by me as an attorney, or a notary can notarize it. And that helps in the long term, because we have sometimes you have individuals who become incapacitated. And if they don't have a power of attorney, someone has to actually file a guardianship application through the courts, which can be a very, very costly process. And it will cost you a good 50 times more
Wow.
than it would cost you to do a simple power of attorney. So that is something that you should also put in place. Another thing that you should think about putting in place is an advance directive. And an advance directive will, a lot of times I hear family members complain about when they have parents or family members that are hospitalized and they're not able to get information. They don't have access to medical records. The doctors won't talk to them. But if you have an advance directive, which one will appoint someone as your basically medical power of attorney, and that person can get information, they can have access to your medical records, they're able to talk to the doctor. But also, in the event that you're not able to make certain medical decisions, that person also is appointed to make those medical decisions. But that is, again, a very, very important role. It takes the stress and the burden off of your family members a lot of times, because people are wondering what to do. But if you set it out in that document, one, again, you appoint someone that's going to be your power of attorney to make medical decisions. That should be someone that, again, you trust, like you said, that's hating on you, that knows, and you should have these conversations offline. And you should talk to this person and ask them, are they willing to take on this responsibility? Because it's a huge responsibility. So you should talk to that person, and they should know what your wishes are in the event you get into certain medical situations. And in that advance directive, not only can you designate a person that's going to be the decision maker, but you can also specify what types of life sustaining treatment you want, in the event you are, in a end of life type of situation, whether or not you want to be resuscitated, whether or not you want a feeding tube, whether or not you want certain, pain relief, efforts to be performed or what have you. So it can be very, very specific, or it can be general, where you can just simply give someone that decision making power after you have spoken to them. But you can also specify in that particular document what exactly you want to happen. So it's a no-brainer. You have to have the conversation with your doctors, have the conversation with that person, and everybody knows, it's clear when those decisions have to be made and you're not able to make them for yourself.
I remembered being a chaplain at Valley Hospital in Ridgewood, New Jersey. And I was on call one day, and they called downstairs to pastoral care and counseling. And I went up to where this young man, and he was young, he had fell in the tub or in the shower.
Which I did 2 weeks ago.
Oh my God.
3
Thank
weeks
God
ago
you're
now.
still alive.
Yeah.
He hit his head. And I could only imagine, like, he had hit his head on like a gold faucet, marble floor, something, because he was instantly brain dead. And I remembered the wife went home and got the DNR. So they had already had these discussions about what this would look like in case this ever came about. And I remembered she had argued with the nurses, and we literally walked around like the nurses station. She was holding my hand and she was apologizing. And because they've dealt with this so often, some of them would look up at her, acknowledge her. Most of them didn't. And she still apologized. Then we walked into the room where he was lying, brain dead, and the family was around the bedside, and she had last words, and I said a prayer because they're priests, they couldn't find them or whatever, and so I went in to serve as that person that would give him last rites. And the beautiful thing about the entire thing was she had the documentation, and then he also had that he wanted his organs donated. So they literally rolled him into the emergency room to operate. And I'm like, wow, this is setting your house in order.
Yes,
This
yes.
is really the
And I forgot
epitome
to
of
mention that,
setting your
yes,
house in order.
right. That's part of the, your advanced directive if you want to, donate your organs. And that's a whole nother discussion because
Yes.
I think people in our community have some reservations about that.
Religious reservations, child. When Jesus called my name in the getting up, good morning, I want to come with all my bodily parts. What?
And I mean, it's your decision, what you want, to do with your,
Right, with your
organs. But
parts.
that is a whole nother segment that
Right,
really we could
right. And I
talk about,
understand that.
because
But she
not just
did.
religious reasons, but other people believe sometimes that their life can be cut short or that certain life-saving measures won't be performed on them because they've decided to donate their organs. So again, it's something that is an issue in our communities, a lot of reservation around that. But I think it's a lot of miseducation. But as I said, that's a whole nother segment that you could, do on
Right.
that. The importance of organ donation.
Well, I would say to anybody before they go online looking for forms to fill out and type in information, to do it with an attorney.
Yes.
And why would you also say that?
Because the forms that you get online are very general. They're not state specific. So if you get a form and you follow it and it's not in accordance with New Jersey law, your will not be acknowledged when you try to probate it. So it's best to do it through an attorney because the attorney knows the law, and the attorney will know what language to put in those wills so that you won't have a problem when you go to probate. Or if you do it and say you don't do it, you do it with two witnesses or you do it with one witness, but you don't have that self-proving affidavit language in there. When you go to probate your will, now they're going to need a witness to come. And if you did your will 20 years ago, and what if your witnesses are not alive, at the time? What if your witnesses passed away and you haven't updated your will? It could be problems. So I would say just be very cautious of some of those forms.
And how often should one update, review it? Because I know we did mine maybe 3-4 years ago. I don't even remember, but it's been a while ago. And so how often should I pull that out and look at it, review it, update it, or what?
I would say at least 3 to 5 years, but definitely when there's a major event that happens in the family, if you have another child or someone gets married or someone gets divorced or someone passes away that you named in your will, perhaps your executor or someone like that. So I would say take a look at your will at least, every 3 years, at a max, every 5 years.
Okay. And any other things that you could tell the audience about the different documents that they need to have and should have in place? Because I don't know what's going to happen with DMX's estate, what
He
that's
didn't have a
going to
will.
look, what
He
that's
didn't have a
going.
will. Aretha Franklin, there was issues. Prince didn't have a will. I mean, so that goes to tell you that it's not about money. I mean, these people have a
So
lot of
what
money,
is it
especially
about?
Prince, and he has a lot of different assets. He's got intellectual property. It's a mess, you know. So, and again, I don't understand because it's so simple. It is when you have a large estate and you have a lot of assets. The hardest part after you get over thinking about death is outlining all of your assets. I have an intake form where I ask everyone, list your stocks, your bonds, list every asset that you own. Now, there are certain assets that don't pass as part of your will. Anything that you name that you can name a beneficiary for, you don't, that passes outside of a will. Now, many people are able to avoid the probate process altogether by simply having their assets either in a trust, or they will designate, they have a lot of assets that allow you to designate a beneficiary, like life insurance policies, pension plans, annuities, anything
Right.
where you can designate a beneficiary, that is going to pass according to who is named as the beneficiary. Or if you own property with someone else, like as joint tenants. So if you pass away, your surviving spouse or whoever is on there as a joint tenant will inherit that property. So those things pass outside of the will. So if you have a very large estate and it consists mostly of assets that you can name a beneficiary, which are called non-probate assets, then more power to you. You can avoid the probate process together. But a lot of times you have a combination of of those kind of assets. People have cars, people have real estate, um, and they have real estate that they own outright. Some people sometimes transfer the deed prior to them passing away, but that could be a good, a risk. But some people have done that to avoid the whole probate process. So either way, have a plan. Whether the plan is to have mostly non-probate assets that you designate beneficiaries for, so you know who's getting what from those assets, out of those assets, or do a simple will
Right.
and
Now,
have a power of attorney, as I
okay.
said, and have the advance directive. A lot of times, the hospitals will allow you to fill out an advance directive before are admitted or during the time that you're admitted. But not everyone's going to be in a state where they can fill that out.
Right.
So have it handy, keep those documents in a safe place, and be prepared. And you will do wonders for your family. It's hard enough that they have to mourn your loss or your sickness or your illness, and they have to deal with that. The last thing they need to be dealing with is fighting over who gets what and trying to figure out, are they going to make the right decision in terms of your health care. It's a lot. It'll take a huge burden off your family.
And that is so key, to take that burden, that pressure off of your family and make these decisions while you are clothed and in your right mind. You have sound mind. Don't wait until you get on your deathbed and someone's bringing you a sheet of paper for you to try to sign. And does that even hold up in court?
Well, I mean, you can have handwritten wills, but it has to meet the, certain requirements.
Okay.
And again, you can have it, but if you don't have the self-proving affidavit and your two witnesses, you're still going to have someone come in and witness that you signed that document. But it will give you a sense of how you want it, property and assets distributed. But as I said, do a will, do a power of attorney, do the advance directive. It's painless. It's relatively, inexpensive depending upon the complexity of your estate. So I recommend that everyone do it.
Karen, Miss Karen Brown, Esquire, I can't thank you enough for this half an hour. I really appreciate our time together. Contact Karen at her law office. Look her up. She is on social media. This has been Setting Your House in Order. Please subscribe, like, and share this video. Share it with others. Don't let people walk in ignorance. Until next time, good morning.
Thank you.
Thank you.